Hello, this is Maureen White here again with you for the second installment for National Consumer Protection Week on the subject of bankruptcy. Yesterday we kind of gave an intro, but today we're going to go a little bit deeper into the different chapters. Today's chapter is going to be Chapter 7, which I referred to yesterday as the sprint. I'm not fond of the term that is often used, you'll see on the internet, which calls it liquidation, because I feel that this term kind of intimidates a person seeking this protection, believing that the trustee is going to take your property, which is not the case. We will go into what are exemptions, but for now I want you to set aside the thought of liquidation and to focus on what Chapter 7s are. When we look at what chapter is appropriate, it is best to really examine the debts. So if you are a debtor that is current in their house payment, current in rent, current in child support, current in their car payment, but is strapped with medical debt, Social Security overpayments, tax debts greater than 3 years, credit card debts, or personal loans, then this is the right chapter for you to consider. These debts are what we would consider unsecured, meaning they don't have collateral attached to them. And the Chapter 7, as we said, is a sprint, so it's seeking to discharge unsecured debts. A common question is, well, I don't want to lose my house. I don't want to lose my car. Well, all debts are disclosed to the bankruptcy court, but secured debts such as your house, your car, your furniture are treated differently. The court will ask whether you want to continue to pay these debts. It is totally your choice to continue to pay the debt and keep the collateral, your house, your car, your furniture, or surrender the debt and discharge the collateral. In most cases, the whole purpose of filing the bankruptcy is to keep your house, keep your car for job purposes, keep your furniture. So you simply tell the court in a statement that you are going to keep these items, you are going to pay these creditors, and that you'll feel in a better position to pay these creditors once the unsecured debt is discharged, because your income will be free to focus on those things which are more necessary in life. So when we go back then to the word liquidation, in all bankruptcy cases, there is a trustee. However, their role is very different, whether they're a Chapter 7 trustee or a Chapter 13 trustee. A Chapter 7 trustee is empowered and entrusted to protect the interest of creditors, which of course is not your interest, but that's his interest. So you keep that in mind because he is asking you questions to see whether or not you have excessive income, excessive property, unexempt property that he might want to liquidate to pay the creditors. So since we're on this subject of exempt, what does that word mean? South Carolina has an exemption statute which is not specifically designed for bankruptcy, but which is used by the bankruptcy courts because it protects the property of consumers. It is very detailed. It talks about real estate. It talks about cars, cash, furniture, investments, workers' comp. The list goes on and on and on. The state adopted this to protect people against the claims of creditors through judgments, which may come through courts. Likewise, it's used to protect the rights of debtors in creditors in bankruptcy. So, for example, if you have a house and you are a single debtor, you have a $60,000 exemption in that house. If you're a joint debtor, you have a $120,000 exemption in that house. So, for example, if your house is worth $200,000, your mortgage is $100,000, your exemption is $120,000. There's virtually nothing there that the trustee will even consider an asset of the estate. So these exemptions are there to protect reasonable assets. Now, if you have a second house, that might be in jeopardy. A second car, a motorcycle, a beach house, a Rolex watch. Those might be in jeopardy. So people that have those assets need to consider this seriously. One of the greatest things about the bankruptcy court is that it does not in any way impact your investments if they are retirement investments. It does not ask you to liquidate 401ks. It does not take your Social Security. It does not impact your workers' comp. The whole idea of bankruptcy is in order to get this fresh start, you need to be able to move on with the assets that are necessary to survive a comfortable lifestyle. So the trustee will generally look at what you've listed, what the exemptions are. If there is no substantial equity in them above your exemption, he'll declare it a no asset case. I can honestly say that in 20 plus years of doing bankruptcy, I have probably had 2 cases where they were declared asset cases. One was changed almost immediately. The other one did have to be converted to a 13. So I want you to understand that the average consumer does not have a lot of equity. Otherwise, they would not be seeking the protection of the bankruptcy court. But I also emphasize the importance of consulting with an attorney that can help you look at your assets, look at your debts, look at the exemptions, and make sure that the bankruptcy gives you the fresh start you want and does not compromise your ownership interest in any of these. Thank you for listening.